Hi, good afternoon, folks. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is a community conference call we do every other Thursday. I'm going to go over the questions that have been posted on the forums first, then take the follow up questions on the forums. And After that, we will do all the new questions. I think we'll have enough time today. And if time permits, I also want to address the pending H4 regulations, work authorization for H4 people, as well as the changes they are considering for outstanding researcher professor category. Okay, so let me get started with the questions that have been posted first. First question is from Nerijas, who has a DV lottery, but he doesn't have an address in the United States. So the question is, for delivery of his green card, how should he present the information in DS-230? Where do you want the green card to be mailed? Should I present a rented mailbox address or a home address? Well, first of all, from what I remember, you cannot use a mailbox address or a PO box for green card delivery. It's got to be a street address. Second, this question can be addressed to the consulate. Just send them an email and see what they suggest. I don't know how other people do it. You have to forgive me because we don't get involved with DV lottery cases. When the lottery program first came out many years ago, we made a decision as a law firm that we will not be doing DV cases because these cases don't really need a lawyer. These are cases where people can represent themselves. So I've been out of touch with the procedures and the minutia and the detail of DV lottery. Okay, so I would say keep in mind, I don't think you can give a PO box number. It has to be a street address. And two, maybe a good idea to send an email to the consulate. And if you don't have time, then just give the street address, see if you can get some kind of a street address. You can always come into the United States and change that address. Okay, so you can go online and file form AR11, and then call the USCIS once you're inside. Call USCIS and tell them that this is your address. Please mail my green card to this address, and they should be able to do it. Now, also remember, if the green card gets sent back for some reason and you're not at that address, you can always track that down and get the green card sent out to you. It's not the end of the world. Next question is from My India, who says, my mother-in-law has filed petition for immigrant visa F3 category. I've got letter from NVC to pay fees, but I have not received instructions to pay for my child. Okay. Now the problem is NVC says at the time of visa interview, Mumbai consulate can ask for the fees to be paid. I do not know what to do. Well, first of all, the way it works is you can introduce a member of the family who's qualified even at the last moment. What is the F3 category? Let me double check. F3 category, married sons and daughters of US citizens. Yeah, your children should be automatically included. So NVC should have sent you a fee bill for the child as well. And if they are passing the buck on to the consulate, I would check with the consulate, email them and say, are you going to have any problem collecting the fees? It's only going to be a matter of procedure. There is no way they can keep the child out. So don't worry about that too much. Don't lose sleep over it. Correspond with NVC also via email. Okay, that way you have a written record of everything that you've done. That's what I would recommend. So email to the consulate, email to the NVC, and peace of mind, because it's not the end of the world. This can always be corrected later on. Okay. Next question is Vishal Pratap. I have an H1 petition approved until 2016 October. So not cap subject anymore, and anyone can file for a transfer. I want to enter USA on tourist visa and then file B2H1 transfer after a couple of months. But that's not a good idea. The reason is that entry can be deemed to be misrepresentational, fraudulent, because you're entering based upon a representation to the CBP at the airport that you are coming in for a short visit, whereas your intention is to convert to H1. Not a good idea. Okay, so if I were you, Vishal, I would come on H1 but not come on B2 and transfer to H1. Not a good idea. People could do this. They could come in on a B and then convert to H through consular processing by going out again. It's too complicated. Come in on H1 if your intention is to be on H1. Okay. Andy 201 says, my sister has a 5-year tourist visa and she's been to US 3 times after that. She applied for F1 visa and has been rejected 3 times. That does not make sense. She has such a good history of coming and going. Wow. Okay, first question. Typically the port of entry is given for 6 months. So if she comes back, even though the visa is expiring in November, she should get 6 months. Even if she enters 1 day before the expiration of the visa. Okay, so normally they should give her 6 months. Second thing, since she has her F1 rejected 3 times, is she eligible for interview waiver program? I don't know the details. Please look at the instructions on the interview waiver program. They change from time to time. I don't know exactly how it applies to her case, so I can't answer that question. If it is not clear, send an email to the consulate asking for a clarification about her eligibility from interview waiver. Okay, I don't know the answer off the top of my head. I haven't looked at the interview waiver program for a few months now. I looked at it when it first came out. Okay, Lavaris, good name, says, my wife should be a citizen soon and wants to sponsor her brothers. That takes almost 13 years. Let's look at the visa bulletin. So I'm at immigration.com, our website, and let me show you how you get to this page. So if you go to immigration.com, and one of the ways you can get to this page is go to popular information, and here you have visa bulletin. Click on visa bulletin. We have visa bulletin for the last many months, and then you can click on the most current one. So I think that's category 5, family 5, family 4. Family 4 is right now for India backed up to 15th December 2001. So it's about 14 years or 13 or 14 years backed up. So you can imagine if a brother sister applies for a brother sister, it takes 13, 14 years. Okay. If she sponsors either brother, how long will it take? I just answered that question, 13, 14 years. If she sponsors mother, mother cannot sponsor, as a green card holder, cannot sponsor a married brother. Okay. If she sponsors an unmarried or a divorced brother, also considered to be unmarried, that would come under family category 2B. 2B for India is backed up 7 years. And that's now. We don't know what it will be by the time they get around to their visa stamping. Okay. So does that give you enough information? I hope so. Just look at the visa bulletin. Next question is from Harish, who says, B Harish 81. He's got an H1B appeal going. How do the statuses move through the appeals life cycle? And how can we know when the appeal is sustained? Well, if the appeal is sustained, your lawyers and your employers should get a decision from Administrative Appeals Office saying that the appeal has been sustained. So it will be a notice, just like an approval notice from USCIS. Life cycle. The appeal life cycle works like this. First, we file the appeal for the H1 to the same office who decided or denied your case. Typically, they have 60 days to decide whether they want to reverse themselves. If they don't, they forward the case to BALCA. And it goes from local office to BALCA in appeal. That's the life cycle. There it stays pending until time comes for it to be reviewed by, sorry, not BALCA, AAO. BALCA is for labor certifications. Excuse my slip. So the deciding officer gets the appeal, 60 days, looks at it, either reverses himself or herself or forwards it to AAO. AAO then keeps it pending depending upon their time cycle. Right now they're pretty good. So in a month or two you should get a decision from them, and that should take care of it. Okay. Arrow 35. I'm on H1 visa and my stamped visa on passport from previous employer is valid, I guess, until Jan 2015. New I-797 with my current employer valid until December 2015. So 11 months more than the visa stamping. Going to get married this November and will be returning in December 2014 along with my fiance. She'll have to go for H4 stamping. Well, not fiance, well, at that time she'll be your wife. So yeah, she'll have to go for H4 stamping. And I don't know how much time they will give her. Okay. Typically, if there is, I think it's 6 months. If it's more than 6 months on your H1 remaining, they will not renew your H1 visa. You can check with the consulate. I see no reason why they cannot make exceptions in normal cases. And normally they should give H4 coextensive with your approval, which is, your approval is good till I guess you're talking about December 2015. So she should get until December 2015, which is your approval. My guess is H4 should be given till December 2015, even though your H1 visa is expiring in January 2015. The reason is because your approval is good till December 2015, she should get visa coextensive with that. Now, can you apply for a visa? I think it's too early, but you can ask them if they will approve. But your visa is expiring, hang on, in December 2014. May not be too early because you are within that 6 months range. You'll be going in November. They should be able to stamp your visa all the way to December 2015. Because in November, when you apply for the visa, but this is November 2014. Yes. And your visa is expiring in December 20. Yeah. You should be able to get your visa stamping done because there's only a month left on your visa. And your approval is till December 2015. So you will be able to get visa stamping till December 2015. But keep in mind, visa stamping of H1 these days is quite problematic. They try to delay everybody. Okay. Next question, GC India 123. After 10 years of waiting for my green card. Oh yeah, you had posted on the on immigration.com website. And I asked you to come join us in the conference. After 10 years of wait, you got an I-140 intent to revoke. Okay. You had applied for a green card with the company A, got the I-140 approval in 2009, changed employers in 2010 to company B, and you have a 485 pending already, started using EAD, changed employer in 2012 to company C, applied AC-21 from company C last week. Case was LC, labor certification substitution. So there were some problems with the company that applied your green card, bribery, kickback. So last week your new attorney sent AC-21, etc., etc. Here are your questions. Will they request any documents from company A or not, as I filed AC-21? I hate to tell you this, but the government position is this. If your I-140 should not have been approved, it can be revoked at any time. Courts have not liked this. There's actually a ruling from Seattle Federal Court very harshly and appropriately criticizing USCIS on trying to revoke an I-140 5 years after it had been approved. Yours is 10 years. So I think you're going to end up in court probably. USCIS will take the position that only your employer A can respond to the notice of intent to revoke. You have no standing because you are merely the beneficiary, not the petitioner. Okay. You would argue, well, I have my AC-21 going and you can't take away that right after so many years. Government will take the position if I-140 should never have been approved in the first place, it gives you no right to get AC-21. might end up in court. Okay, and I deal with cases like this all the time. Chances of getting approval are small. Chances in court are relatively good because depends upon the judge and the court and the jurisdiction. Judges don't like these kind of cases. They're very unfair because for no fault of yours, 10 years down the line, they're trying to disturb your status. Okay. Last question was, since I have already filed AC-21, does this mean the letter USCIS sent becomes invalid? No, they can still come after you. I would also, if I were you, I would also start a green card process, a new one, just in case. Okay. So, not good news. You might end up in court. Start looking at that as well, okay? Hari 27, worked in company in India, applied H1B in 2008, went for stamping, got my H1B approval till 2011, quit that company in 2010, never came to USA, got my F1 and came back in 2011, completed my master's, and now they are creating some problem because your university does not qualify for advanced degree. So the question is, can you say that the H1B was applied by mistake in master's cap? I think it's too late for that. You can try to make that an argument. I don't think it's gonna fly. Can you transfer your old H1B? I think there your chances are much better because within the last 6 years, you were approved for H1B. So you can probably take that route as well. In responding to this RFE, you could take all these arguments, saying that hold me, if first of all, hold me to general quota, if not masters, because you have put me, I have come under the lottery, so you should be putting me in that. In any case, if that is not the case, then hold me outside the quota because I have an approval within the last 6 years. Let's see if that works. Sri Park, EB1 filing options. So, move to USA on H1B with the top 10 MNCs. Software professional, master's degree, manager at my firm. Company can locate me globally. Can you tell me options for EB1? It's a very good idea. Here's what you should do. If they can transfer you as a manager or executive anywhere outside the US for 1 year to a sister, daughter, or allied company, you should be able to, after 1 year, come back on L1 or directly on green card if you like. EB1 green cards take less than a year to process, a few months only. So potentially, after leaving USA, you could be back within a year, after a year on L1, or within a year, year and a half on a green card directly. Just make sure of one thing. Have your corporate structure reviewed by your lawyers as well as your job description for the proposed job to make sure it meets the L1A/EB1C requirements. You don't remain on the same company's payroll. You will be on the payroll of the company or the sister company for whom you will be working outside USA. Okay. Next question is also EB1C question from A. Mangar. You had also left a message on immigration.com. I remember answering your question. You were on L1B, then you converted to L1A because you worked outside in a non-managerial capacity. Unfortunately, as far as I know, I could be wrong about this, I haven't looked into this for a while, I think you have to have 1 year outside USA as a manager to get green card. You can get L1A based upon your work here, but you cannot get green card like that. Okay. So Mr. Mangat, I think you have a you have a conundrum here, a problem. You may have to go outside USA for 1 year. Have it double checked by your lawyers. I think this is the law, but I cannot tell you that I know it beyond any reasonable doubt. Okay. Next question. Excuse me, I'm just a little bit of allergy season. So here's the case. Left company A while perm EB2 was pending. Then the perm got approved. Now I'm with company B. On H1B, got my capture time. A is willing to proceed with I-140 and 485. Question 1. Can I continue the process with company A? Yes, you can. Even though you're working for company B. As long as at the time of the filing of the I-140 485, you do have the genuine intention to join them. You may never join them, but you have the intention to join them. Second option is, of course, I-140 priority date transfer. You can do that as well. Why can't you do both? Why can't you do both? That's what I would recommend. So file I-140 485 if you have a good faith intention, as well as do a perm-based filing through the second company and transfer the priority date. Something goes wrong, you got both options. SCS 777. There was a conference call on entrepreneurship on EAD, and I had suggested to see the video from my blog. They have watched the video about how to do business in the United States. Still on H1B, looking for a similar job to switch using AC21. Can I open a consulting company while I'm on H1B? I had a radio conversation yesterday about this. You can actually form a company, you just cannot manage it. You cannot be involved in running the company at all, not even signing a check or a contract. You should switch to EAD and then start managing the company. You can register now, but you don't want to do any business on it. Opening a company in India, on the other hand, is no problem because you are not doing business on American soil. Okay. Now, I have answered the questions that were posted on the forums. Folks, anyone has any follow-up questions, please press, I think it's *5. Press *5 only for follow-up questions, no new questions. *5. 2, 3, 4 questions. Okay. Now remember, these are follow-ups, no new questions. After I finish these, then we'll do new questions. Let's begin in the order in which you guys logged into the conference. So New Hampshire, please go ahead. New Hampshire.
Yeah, hi Rajiv, this is Satish.
Hi Satish ji, how are you?
I'm fine. The follow-up questions are like, if USA revoke my 140 due to fraud or some misrepresentation, can I take my PD to new company? Because actually it's my LC substitute, right? So can I take my labor with me to the new company?
No. First of all, the substitution rule is gone. Okay. You can no longer do substitutions. Okay. Second, the posture USCIS is going to take in all likelihood is this. They are going to say this I-140 should not have been approved in the first place. Because it should not have been approved in the first place, it can therefore be revoked without any problem. The issue relates back all the way to substitution also, because substitutions are no longer allowed. So since 2005 they have not been allowed. You cannot really take it to another company. So I think what you should do from a planning perspective, start another green card. Okay, just to make sure you got something in the works. In the meantime, I have a very strong feeling you're going to end up in court. I am actually assisting 3 or 4 other people who have hired lawyers locally, and their lawyers are consulting with me on how we suggest these cases should be handled. So you may end up doing something like that, getting a lawyer who's experienced with these kind of cases, or getting somebody involved who can file a lawsuit against the government. And one of the things you can ask during that is that your EAD should be continued. Okay, so starting a second green card is a very good idea for you.
Okay. The second one is if my the old employer is not supporting me or not sharing the query what USCIS sent, so can I request from my new attorney?
You should definitely respond to it and make the argument that you are the one being hurt, and because you are the one being hurt, you should be allowed to respond. And secondly, you should be allowed to respond because even though you are not a petitioner in the I-140, you are a direct beneficiary as well as the petitioner in the AC-21 case, and that case is also getting revoked because of this I-140. So therefore, you should be allowed to respond to the I-140 notice of intent to revoke. Definitely respond, otherwise it will be difficult for you to make a case in court.
Yeah, but if the old employer is not supporting us, not sharing the document, how to get that?
Do the best you can, send something out. You have an I-140 approval, attach a copy of that. Say that it is my understanding that a notice of intent to revoke has been issued. I would like a chance to respond to that. Do the best you can. That makes it a good case. That makes it a good case for appeal. Appeal again they're going to throw out, but at least you would have tried. And that makes it definitely a good case for court.
Okay. Somewhere in the forums I read like even if it's revoked, old employer revokes I-140, after we're doing AC-21, it's a good case. Like it's not going to deny, right? That's what I heard from the forums. So
No. Hang on, Satish ji. There is a difference. An employer revoking I-140 and USCIS revoking I-140 are two different things.
Okay.
When employer revokes, your AC-21 remains undisturbed. When USCIS revokes for fraud or misrepresentation, everything gets to go away. Nothing survives.
Okay. I mean, I'm still not sure like what exactly USCIS sent in the letter. Is it employer revoked or USCIS revoked? I don't know, right? I mean, we don't know in that context what they sent, updated online. So well, that is one thing. And how many days we will get to reply this letter?
I think notice of intent to revoke is 30 days. 30.
Okay.
And if by mail, 33 days. So 33 days. I have seen them issue notice of intent to revoke with 15-day deadlines also. I'm trying to remember I think that could be 15-day deadline too. Just be safe rather than sorry. Try to make sure you respond as quickly as possible. So I have seen 15-day deadlines and I have seen 33-day deadlines, both of them.
Okay. So you said I might end up in a court, right? So on which visa I will be continuing or I will be fighting the case in the court? EAD? Continuing the EAD?
All up in the air. Can't really say which visa will end up. This is a fairly long discussion you've got to have with your lawyers who are going to litigate the case for you. One good thing is, even after they revoke your I-485, nothing permanently bad happens for 180 days. Only after 180 days you become subject to 3-year bar. So you'll have some time to resolve these issues. But start working on getting competent lawyers involved, litigators involved. Talk to your lawyers what they suggest. I think you're going to end up in court.
Okay. Thank you, Raju.
You're welcome, Satish ji. Good luck. Sorry to hear about this. This really sucks.
Yeah.
Good luck to you, sir.
Thank you, Raju.
Okay. Massachusetts. Go ahead, please, Massachusetts. Massachusetts, I can hear you. Area code 617. Go ahead.
Hello, Raju.
I think you're referring to me. I'm Harish.
Yes, Harish, how are you?
Um, yeah, I'm doing good. How are you?
Good. Tell me.
Yeah, yeah. And actually, this is about the denial of my visa, and I had applied for the appeal. Now, it's been a month, and we have also submitted the evidence. My question is that since they say that it can take probably 6 months or even years for a decision to be coming on a appeal,
No,
I'm
no, no,
planning to
no, no.
move to the
Hang
US
on,
at some
hang
time
on,
and come back.
hang on, hang on,
Uh,
hang on, hang on, hang on. Stop right there. Stop right there. Stop right there.
Hello?
Stop right there. Administrative Appeals Office times have become quite good. Okay? So
Oh,
I don't know when was the last time you guys looked at the AAO times. So I'm at immigration.com right now. And again, I'm looking at popular information drop down. And I am looking at, let's see, processing times and status checks. I click on that link. Give me a second. And let us see. USCIS Service Center processing times. Here it is, Administrative Appeals processing times. So I'm looking at the Administrative Appeals processing times as of April 2014. I'm clicking on that link. I-129 for H-1B is current. There is no backlog, not even one day.
oh,
Okay? If you
yeah.
watch the video, it'll tell you exactly where to go on our website. Our times that we have are current as of last month, and it's clearly showing that there is no backlog in H1 processing times.
Okay.
So appeal should be quite immediate. Therefore, the question you were going to ask me will have to be rephrased. What other question you have in view of this?
Yeah, meaning if I'm say, going back to India, probably coming back after stamping, with this denial will be an issue when I'm coming to stamping.
Well, if the denial is not based upon any fraud on your part, I don't see any reason why a fresh H1 would have any shade or negativity because of this particular denial. So I don't know what the grounds of denial are, but typically these grounds of denial are you don't have an end client letter. And that has nothing to do with you. So if you do another H1, this particular case should not have any bearing on it.
Okay.
Okay?
Okay. Yeah. Thanks, Raji.
You're welcome. Good luck, sir.
That's great. It's great help. Yeah. Thank you.
My pleasure. Bye bye. Okay, let's see. And this is my neighborhood, Virginia. It's a cell phone from Virginia. Go ahead, please.
Hi, Raju. Hi, Raju. This is Hamid.
Samirji, how are you?
I'm good. How are you, sir?
Good. Tell me what's going on.
Yeah, I'm working on L1B as.
Oh, hang on. New question.
Java.
Hang on. New question or old question?
It's a new question.
You have to wait. I'll be with you. Hang on. Okay. New Jersey. Go ahead, New Jersey.
Hey Rajiv, how are you?
Good. How are you, sir?
Good, good. Rajiv, just as for the follow-up about my sister's B1 visa, tourist visa. She's going to come in June of this year for 2 months. And as I said, her visa expires in November. So what is the potential port of entry she's looking at? And is she going to have any issues at port of entry?
Andy, I don't think she's going to have issues because her visa is expiring in November and she's entering close to it. That is not a problem. I don't see that as an issue at all. Even if she shows up one day before the expiration of the visa, she should still get 6 months. I don't see that as a problem. The only problem she can have is if she was here rather closely in time before. When was the last time she came to USA?
She came in 2012.
So yeah, I don't see any problem here.
But for only like a month.
I don't
And
see.
she's already traveled there like
Yeah.
3-4 times.
I don't see any problem, Andy.
And when we filed for her renewal, she just completed her studies, is it better that she has a job, or what is the time frame you would recommend if she goes back in November, in let's say August? They're flying back in August. My parents are flying back with her
Look,
in August. When should she apply for renewal?
normally I don't recommend uh, any kind of correspondence with consulates on tourist visa, business visa, or student visa denials. But I think it may be worth your while to have a lawyer write to the consulate and ask them. This is a textbook case in which an F1 should be given. She's been to the US so many times and gone back. How can you deny her F1? So I think it is at least worth one letter to the consulate. And if the consulate still declines to issue the visa, that same letter should be sent to the National Visa Center in Washington, D.C. And an opinion should be sought that to us, we are confounded. This is such a good case for an F1 visa. Why are we not getting the visa? Worth pursuing it that much.
Yeah, but see, I mean, I don't want to mess around with the chances of her getting, B1 renewal, a tourist visa renewal. But I mean, is it going to be?
Sure, I think that's okay too. If you want to have her apply for a tourist visa again and you feel more comfortable with that, I think that's fine. What was your
I mean, she's
question?
done her study. She doesn't want to study here anymore. But all I want is for her to get extension to the tourist visa that she already has, and for them to not deny the tourist
Sure.
visa.
Sure.
So what would you time frame, as in like she goes back in August, her visa expires in November. When should she file for an extension? Should she get a job in India so that she can show more ties in India?
Just look at the interview waiver program. It tells you how much gap there can be between the expiration and the new visa stamping. I'm sorry, I don't remember all the times and the details off the top of my head because so many countries have different kinds of waivers. It is impossible to keep track of them singularly. So what you should do is look at the waiver program. If they allow you or they want you to file within a certain time period, make sure you do that. I don't have any particular recommendation how early to apply.
Okay, but is the F1 rejection going to hurt her chances of getting tourist visa extended? Extended as in renewal?
I do not know the answer to that question because I don't know what the grounds of denial are. I don't know how it affects the interview waiver. You'll have to look that up. But as far as the denial of the F1 being problematic for the tourist visa renewal, that's impossible to say because I don't know what they were thinking. This is such a good case for a student visa approval. So I don't know what they're thinking.
All right.
All right.
Probably, yep. Thank you. I'll look it up with the lawyer. Probably I'll call your office.
Might be a good idea. It's worth a shot. Good luck to you, sir.
It is. I agree with you. I totally agree with you. Thank you so much for the information, Rajiv. I appreciate it.
You're welcome. Bye-bye. Okay, let's look at Arizona. Arizona, go ahead, please.
Hey Rajiv, I had posted my name over there is Arrow 35, and I just had one small follow-up.
Hang on one second. What question number are you?
Sir.
What question number are you?
I think number 8.
Number 8.
So it was regarding the H1 stamping.
One second. Oh, yes. I remember your case. Go ahead, please.
So I just wanted to ask you a question regarding the second point. You mentioned that I can still go and do the H1B stamping even though my visa is valid. But
Yes.
I think something on the books that says these many months before the person can go for stamping even though the visa is valid.
Right.
This is just like.
I think the period is either 4 or 6 months. Yeah, it's either because you will only have like a month left. So I have no doubt that you'll be able to get it done. But you know what you can do? You can send them an email also. Okay, send them the U.S. consulate in India.
Oh, okay.
Okay, And also send an email to the U.S. consulate in Canada, or where are you located? You are in Arizona. You can send them an email to the U.S. consulates, one of the consulates in Mexico also, and say I want to come for my stamping before I go to India, and I've got X number of months on my H1. Will you entertain the application, or does it have to be a certain number of months? I think it's either 4 or 6.
4 to 6 months. Is there anything mentioned on the USCIS website that I can pull out or something?
See, remember, it's not USCIS now; it's the consulates, State Department.
Oh,
So
okay, yeah.
go to I think it's visas.gov, visas.gov.
Okay.
Let me double check for you. 1 second.
Okay.
No, that one is not available. Maybe it's Visa.
Or maybe I can just Google the visa.
Actually, I know that you can go to travel dot state.
Travel docs? Yeah, travel docs, okay.
No, travel, TRAVEL, travel.state.gov.
Okay.
That site has all the US. It's usvisas.state.gov.
usvisas.state.gov, right?
Yep, usvisas.state.gov, and that should give you all the information you need.
Okay, but you are fairly confident that it's usually 4 to 6 months, right?
I'm quite confident about that.
Okay. And another question I had was, is there anything special I need to do? I just need to fill out the DS-160 and the same procedure I need to follow, right? Or is there anything
Same.
special that I need to do because I'm applying for my visa, even though my visa is valid, or it's the same procedure?
Same procedure. Also look at the interview waiver in India. If you qualify for interview waiver, you might be able to just hand over your passport and then collect it.
Oh, okay. But since my fiance cannot do all these things, right? She has to definitely appear for the interview.
She'll have to appear for the interview, yes.
Okay. And even though if I'm not qualified for the interview waiver program, me and my fiance can go in the same slot and give the interview together, right?
I believe so, yes, sir.
Okay. All right. I will look into all the information that you provided. Thanks a lot, Rajiv, for your help.
Always a pleasure, and congratulations.
Thank you. Thank you very much.
All right, bye-bye. Okay,
Bye-bye.
let's, okay. Now we have, I have put everybody's hands down. So any questions whatsoever, please press *5 on your phone. Everybody, *5, any questions? 1. Even the gentleman from Washington, D.C. Yes, you are up now. I see you. Okay. 5 questions. 5 people with questions. Okay, no problem. So these are the new questions we'll be dealing with. Again, I'm going to go in the order in which people logged into the conference call. New Hampshire, go ahead, please. Nashua, New Hampshire.
Hi Rajesh, sorry, I put in mute. The question is about if I get an ability to pay on my approved I-140. So in that case, I already moved to a new company, right? Still, I need to give reply from my old company.
Is the I-140 approved or pending?
Yeah, this is question number 10.
Oh, okay. So you are not a new question. You are. Hang on 1 second.
Yeah. If suppose I get any ability to pay on my approved I-140, and I already applied AC-21 last week, right? And recently I got update of intent to deny.
Oh yeah, you're not.
Right?
You're not
So,
question number 10. You're question number 9. Okay.
Yeah, sorry.
No problem. So yeah, see, the thing is, you cannot really respond to ability to pay wages because you won't have their tax documentation.
Yeah.
So you do the best you can. That's all you're going to be able to do.
No, I mean my old employer can if he is able to support, it's fine. But his company is already shut down. I mean only 3 or 4 H1s he's holding. Earlier he used to have 100 H1s, but he sold the company to another company, and another company transferred all the H1s except 3 or 5 because they are not approved from USCIS, H1 transfers. So they are still running like 3 or 5 payrolls, H1s, on the old company. But if they sent on a query about ability to pay, and if the old employer is not able to provide financial, is not able to support financially, then how my case will be affected? Because I already obtained my AC-21 and moved to this new company, right?
You'll have the same problem if the case, the I-140 can be revoked. But here would be, this is a very complicated situation. I'm not going to be able to deal with every aspect of it in just the few minutes that we have. It's not something I can answer and explain to you just in a few minutes, but I can give you some idea about the complexity of the issue. USCIS, and I'm only going to take 2 more minutes because I've got other people waiting. USCIS can always take the position, number one, that the I-140 when approved should not have been approved. That means ability to pay wages can be raised to the point when the I-140 was approved. There is also law on the books that says you have to maintain your, or the company has to maintain their ability to pay until you actually get your green card. So then I would say they could go all the way up to 180 days from the date you filed the 485. After that, you became AC-21 eligible. So not only can USCIS deny the case based upon the fact at the point of the filing of the I-140, the company did not have the ability to pay wages, but also that 180 days past that point, they didn't have it. They can take the position you've got to maintain it longer than that, but I think they have a weak argument. Your argument that after 180 days I'm AC-21 eligible, you can't hold me to their ability to pay would be strong. So that in a nutshell is your situation. Please don't go nuts about this. It's something your lawyers will have to sort out. There is no way you can understand all the legal implications of everything involved here. Please have them review it. Make sure you sit with them, let them brief you about what they're thinking of doing. I can give you pointers, but I can't really take it beyond that. There are so many implications. A lot depends upon what they went after the company for. If it is active fraud, they are going to find any way they can to deny this case.
Okay, got it.
Good luck to you.
Thanks, Raj.
You're welcome.
Yeah.
Okay, we have 4 more people, last 4 people. Let's go to my neighborhood, Washington, D.C. Cell phone. Go ahead, please.
Hello, Rajiv ji. I'm Samir.
हाँ जी समीर जी बोलिए.
So I'm currently working as architect on L1B visa.
Okay.
So my company is willing to sponsor green card as a Java senior Java developer.
Okay.
So will that be okay, or will that create any problem? Because I'm working as an architect.
When you say architect, are you talking about software architect or building architect?
Yes, yeah, software architect.
Of course, that's fine, no problem.
Okay, so it's like I'm going for a lower position, so it shouldn't be a problem, right?
Well, it depends. I mean, what are the reasons for going for the lower position? Your lawyers can help you decide that, but it is not unheard of. Many times what happens is you are working for a company, temporarily they have a need for a few months to fill in a higher position, but they intend to bring you back to the lower position. These are some typical examples of why you will be given the lower position, but certainly I don't see any problem with it.
Okay, yeah, that's it.
Good luck to you.
Thanks a lot, Rajiv.
My pleasure, Samiji. Good luck. Okay, let's, what did I do? Okay, 3 more questions. Let's go to Pennsylvania. Pennsylvania, cell phone, go ahead, please. I can hear you, Pennsylvania. Go ahead, please.
Hello.
Yes,
Rajiv?
go ahead, please.
Hi, my name is Kolli Reddy. I have a question regarding my I-140.
Yes, sir.
when I filed my I-140, my company was Company A, and it was acquired by Company B in October 2008. And now my date become current effective from June 1st. It's a EB3 case with October 2003 priority date.
Okay.
My attorney said I need to file successor and interest application for the one that's already approved with the old company. And they said we have to do it as a brand new application. The problem is the job skills and the job description what I had on the labor petition that was filed in 2003 is totally different from what the job description and the skill set I have now. It's the same technology line, but I had it as the term says computer programmer. Now I have a senior technology architect. And the technologies are old technologies versus new technology. So on the other hand, my company filed a EB2 labor petition that is in audit review with a priority date of March 2013. The current dates are January 2013. So my attorney is saying you have more risk filing for successor and interest application. You would rather wait for 2 more months to get the EB2 form approved so that you can go with a clean process rather than trying to do successor and interest and all that with old company approval for I-140. So I would like to get your suggestion on what is the better approach.
Very difficult question to answer. I have to look at the 2 job descriptions. I would have to talk with the employer. Many times what you think as very different positions can be pretty much similar or substantially similar in the eyes of the law. So I really cannot answer that question. Broadly speaking, I agree with your lawyers, broadly speaking. But until I actually, see, I also know technology. It's kind of interesting. With me, what happened was my first degree is in biology and chemistry. But I always wanted to study law. And once I studied law, I got involved with technology so much that I have developed a lot of horizontal knowledge base. So I can tell a lot more than most people can. A lot of lawyers may not be able to tell the difference between code and an executable, okay, or between a client and a server. So, but somebody needs to look at the job descriptions, compare them, and decide if they are substantially similar. If they are substantially similar, I would like you to file your I-140 485 when the priority date becomes current. 2 reasons for that. One, you've got the AC-21 benefit, and 2, what if your labor cert does not come out of audit? Well, what if it gets shot down? Okay, so I think this has to be examined very carefully. In principle, I agree with your lawyers. What they're saying makes good sense.
My technical manager from my company reviewed both the descriptions and
it is not the technical manager's job. The technical manager can only look at the job from the technical perspective. This is a technical and legal combined perspective.
Oh, okay.
Okay, because the criterion is substantially similar or substantially dissimilar. What does that really mean? I would say if the essential nature of the job is coding, technologies, requirements are about the same, we can make a good case for substantially similar job. Okay, so I can't answer this question in a vacuum.
Okay, and can they file the successor and interest in premium process, or it has to be a regular?
Well, that question depends upon whether or not USCIS has in their files a current copy of your, or the original of your labor certification. USCIS has said you can file I-140 premium if we, USCIS, have in our possession your original labor cert. But if we have archived it, we won't accept it premium. So you can try.
Oh, okay. Like, do they have to file the successor and interest also as a brand new I-140, or it would be an addendum to the already approved one?
There is no such thing as an addendum. It is a new I-140.
So it's a new application. So it will go through the just normal process, just like any other I-140.
Yes, sir. There is no special consideration or speed for it. Okay.
Oh, okay. Would it take longer than a regular I-140, or like it would be the same processing time?
I do not know the answer to that question. My own experience about the same.
Oh, okay.
Okay. Good luck to you.
I have one more quick question.
If the questions can be quick, but the answer has to be quick too. So go ahead, please.
Sorry, okay. When they denied my my 485 earlier, the USCIS did not deny my wife 485 petition. My attorney said it was an orphan record and nothing would happen, and eventually it gets rejected. But recently we got a RFE on that petition. So do we have to respond to that RFE, or can we ignore that and file a new one with my I-485 new petition?
The general rule is never ignore anything. You should send a letter back explaining the circumstances.
Oh, okay.
Okay.
And we don't have to wait until they deny that to file a new one, right? We can just send the RFE response and as well as file the new one at the same time.
That's what I would do, yes, sir. Okay. I've got to. Good luck. Bye-bye.
Okay, thanks.
Okay. So last two questions. Let's go to Wheeling, Illinois. Go ahead, please, Illinois.
Hello, Rajiv. This is a follow-up question to question number 10.
Number 10. 1 second.
Mm-hmm.
Oh yeah, the master's degree becoming problematic.
Mm-hmm.
Yeah, go ahead. Yeah, go ahead, Hari.
So, is it better to reply to the noise and asking me to consider for tax exempt using the old H1B, or do I need to wait till that H1 gets denied and apply a new transfer?
I would argue in the notice of intent to deny both things.
Okay.
Doesn't hurt. I mean,
And
doesn't hurt. What can they do? After all, they want to deny the case. Argue everything that you got.
okay. And one more question regarding my old H1. Does USCIS require a I-94 for my visit on the old H1B, or is that okay?
Not I-94. They just need the approval notice.
Okay.
Because technically, when you left from USA, you would have surrendered your I-94.
Okay. I'm asking about the old H1B, which I never visited.
No.
If I apply
Just,
for a transfer.
just the approval notice should be enough.
Okay. Okay.
All right.
Thank you, Rajiv.
Oh, you're welcome. Good luck. Last question of the day, folks. I was hoping to be able to cover some more ground, but we've already gone about an hour into this, actually a little bit over. So maybe we'll do the H4 topic some other time. Let's just talk with Texas. Texas, go ahead, please.
Yeah, hi. Hi, Rajiv. This is Shubha from Texas.
Ji, ma'am.
Actually, I'm a new citizen of the United States, and I want to sponsor for my dad's green card.
Sure.
But he doesn't have his birth certificate, and it is very hard to get it. He's born in 1936 in Mumbai. So nowadays, consulate in San Francisco or Houston, they are issuing birth certificate based on passport, or they are ready to give no record found certificate. So it will be acceptable to USCIS, or?
Well, the good news is we have dealt with many cases like this, and all of them have gone through. So Don't worry, it will work out. But here is what you should do. First of all, get a notice of non-availability or some kind of a letter from the city municipal corporation where your dad was born, saying that there exists no record of his birth. It's called non-availability certificate, but there really is no name for it. It can be just a letter. From the municipal corporation, if it's a village, from the village panchayat of where he was born, saying there is no record of his birth. Are you clear?
Yeah, I'm clear, but the problem is nobody is over there to follow those things.
It has to be done. Otherwise, it will be very difficult. I'll come to the other matters also, but let me begin with this first. Okay. So once you have the non-availability, then you get 2 affidavits from people who were alive when your dad was born. They don't have to have been adults. They just have to be alive when your father was born, who can testify as to his date of birth. Okay. Now, if for whatever reason you are not able to get this evidence, your last ditch effort, and that can get complicated, I would suggest you get a lawyer. You can tell the government, you know what, do our DNA testing. We had a case like this, and in that we did DNA testing, and that works out just as well. Okay, but please don't do it yourself. If you are not able to get non-availability and 2 affidavits, get yourself a lawyer. You'll be better off.
Oh, so consulate birth certificate doesn't work.
Oh, that does not work. No.
Oh, okay. Okay, Raju, thanks.
All right.
Thanks for your help.
You're very welcome. Good luck.
Okay, thank you.
Bye. All right, folks. As always, it's great talking with all of you. I will see you next Thursday. Like I said, I was hoping to address some issues. Actually, next time onwards, we might do a live broadcast on YouTube, so more people can perhaps listen in and participate. We'll see how it goes. I'm still testing that. All right, folks. Thank you. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.